state unit of Shakti, the National Movement of Women. And Ruby is representing the Indraprasth Shakti here. Ruby, now we are just only 4 minutes late, and so I think we should start immediately. Over to you.
Actually, very good evening to all of you. And not only me, I think we all women here, and we all are part of, like, we are Shakti. Okay. So that is the name of, one organization that works, as rightly said by Punita ma'am, is working for women, or basically women in sciences, or women having the temperament of science, or and entrepreneurship, and many other domains. And one of the domain that has been initiated by National Shakti, that is Yuva Shakti Abhiyan. So that has already been, like, I think since here Punita ma'am is already around, so she must be telling you everything about the Shakti as well as the Yuva Shakti Abhiyan. तो मैं इतना ही कहूंगी कि शक्ति वैसे भी जो है, जो सोर्स एनर्जी का सोर्स है, तो हम सब शक्ति हैं, एंड वी आर ऑल वर्किंग. सो हम सब के पास कुछ ना कुछ थोड़ा थोड़ा, जिसको कहते हैं, we all are working in our domains, our zones, we live in our like parameters, but थोड़ा अगर हम कुछ देना, जिसको कहते हैं, in terms of knowledge, in terms of whatever we can do for the society, for enlightenment. And we as a, like ma'am rightly said, हम लोग education field से belong करते हैं. कनिका जी हैं, she is herself, I would rather, if you see her biodata, she herself is from our like organization, institute, or Delhi University. Yeah. So for you young girls, I would like to say कि कुछ भी मतलब सोचना और उसको पा जाना is not very like बहुत मुश्किल काम नहीं है. हमारे वक्त में इस तरह का कोई बताने वाला नहीं होता था, और हम लोगों को ऐसे कोई वर्कशॉप्स या इस तरह के कोई बातें नहीं होती थी करने को. हाँ, कहीं ना कहीं घर में एक तरह का माहौल या एनवायरनमेंट था. सोशल मीडिया नहीं था. सोशल मीडिया अच्छे के लिए भाषी माध्यम से आप सबसे जुड़े हुए हैं. ये एक तरह से कह सकते हैं कोरोना ने हमें ये चीज दी है, बट उसका जो एक दुरुपयोग भी हो रहा है. और आज का जो यूथ पॉपुलेशन है, मैं आप सब गर्ल्स से कहूंगी, आप पढ़ कैसे लेते हो बेटा? पढ़ने का समय या फिर वो मोटिवेशन कि हमें इस वक्त पढ़ना है, एंड आई डोंट हैव टू सी द सोशल मीडिया साइट्स, इज रियली अ चैलेंजिंग थिंग. हमारे टाइम के चैलेंजेस बहुत अलग थे, तो अभी भी चैलेंजेस हैं. तो ये कहना मैं बिल्कुल नहीं कहूंगी. वी ऑल बिलोंग टू योर जनरेशन, हम आप ही के जनरेशन से हैं, हम क्यों कहें. और इस शक्ति में काम करके वी ऑलवेज फील आवर सेल्फ एज अ यूथ, क्योंकि देना हमारा इस भारत, हमारे राष्ट्र का हमारा स्वभाव है, हमारे अंदर है, हमारे जीन्स में है. एंड व्हेनेवर जो छोड़ के खड़ा है वही बड़ा है, ये ऐसी बात कहते हैं. तो जो हमारे अंदर एक खुशी आती है, तो इस तरह के जो काम है ये वही लोग कर पाते हैं, इस तरह के थोड़ा सा अपने बिजी शेड्यूल में से, जिनके अंदर एक है जज्बा है कि नहीं, मुझे मेरे में से कुछ ना कुछ देना है, पर मैं दे कुछ नहीं रही हूँ, मैं पा ही रही हूँ. क्या वो जो अंतर की एक खुशी है, एक मेरे को मुझे अपने आप में, हम सब में एक सेटिस्फेक्शन है कि यस, आई एम एबल टू कंट्रीब्यूट. सो वी ऑल आर सेल्फिश पर्सन, ऐसे कह सकते हैं कि हम अपने लिए काम कर रहे हैं अगर अंदर से देखें तो. दिस इज ऑल द थिंग. शक्ति के विषय में ज्यादा नहीं कहूंगी. यस, इट इज अ पैरेलल ऑर्गेनाइजेशन, और कनिका जी herself is a lifetime member of विज्ञान भारती and शक्ति. सो ये भी हमारे अपने मतलब मेंबर्स में से ही है, तो उनको उनके सामने समक्ष कुछ बोलना, जिसको कहते हैं कि सूरज को दिया दिखाने वाली बात है. सो आई विल नॉट स्पीक अप, लेकिन यस, वी आर वेरी वेरी थैंकफुल कि जब भी हमने कनिका जी को याद किया है, whenever at a platform of विज्ञान भारती, at a platform of शक्ति, वो अपने सारे बिजी शेड्यूल से हमारे मतलब हम कह सकते हैं हम थोड़ी सी लिबर्टी ले लेते हैं अगर हम एडमिनिस्ट्रेशन फील्ड में नहीं हैं कॉलेजेस में, बट उनका पूरा जो वर्क है वो पूरा 9 to 5 वाला पूरा सिस्टम है. एंड एज ए वुमेन हम सब यहाँ गर्ल्स हैं, वुमेन हैं और आगे आने वाली माएँ हैं, तो सब चीजों को बैलेंस करते हुए चलना और बहुत सारी प्रॉब्लम्स को फेस करते हुए चलने में और इस तरह के वर्क कल्चर को दिखना, तो शी इज एक्सट्रीमली, मतलब जिसको कहते हैं कि वी आर वेरी थैंकफुल कि हमें ऐसा स्पीकर आज मिला और हम लोग उनको सुनेंगे. तो इनका अगर बायोडाटा की बात करें तो मैंने खुद ही कहा था कि मैं इनका बायोडाटा खुद ही पढ़ना चाहूंगी. So let me just once check. Yeah, that has been sent by Savita, and I'm very very thankful to the Kalindi College, especially Nana ma'am and Punita ma'am and the Savita who is coordinating the entire. Today is the 5th day of this Yuva Shakti Abhiyan. So congratulate all of you कि इतनी हार्ड वर्क से आप लोग सब लोग इस प्रोग्राम को कर रहे हैं. तो मैं शॉर्ट में ज्यादा समय ना लेते हुए,
रूबी जी, मेरे साथ सविता के अलावा प्रोफेसर पुष्पा बिंदल, प्रोफेसर रचना 3 दिन रही हैं और अब मेरे साथ हैं मेरी सीनियर कलीग्स डॉक्टर सीमा, डॉक्टर सुधा. तो पूरा डिपार्टमेंट ही लगा हुआ है शक्ति और इन युवतियों की सेवा में, टीम इंद्रप्रस्थ शक्ति की सेवा में, देश की सेवा में. तो ये सभी मेरे साथ हैं और सभी काम कर रहे हैं ताकि युवा शक्ति अभियान का ये कार्यक्रम संपन्न हो सके भली भांति. प्लीज कंटिन्यू, प्लीज कंटिन्यू.
जी, सो पुनीता मैम हैज एडेड. नाउ मैं थोड़ा सा बताऊंगी और मुझे जान के बड़ा अच्छा लगा कि डॉक्टर कनिका मलिक हैज रिसीव, शी इज लाइक ग्रेजुएट फ्रॉम बॉटनी फ्रॉम यूनिवर्सिटी ऑफ दिल्ली एंड पोस्ट ग्रेजुएट इन बायोटेक्नोलॉजी. Then she has like WIPO Academy course with distinction. Then she has a very like 25 years of professional experience, out of which 17 years in the field of intellectual property right. So हम उनसे आज सुनेंगे. She has performed research in the field of biotechnology at 2 of the most prestigious Indian Institute, National Research Center for Plant Biotechnology, New Delhi, and National Research Center on DNA fingerprinting at National Bureau of Plant Genetics Resources, New Delhi. So what else I can say? She is like presently she has served as an examiner of patents and design in Delhi branch patent office with Ministry of Commerce and Industries, Government of India. She is actively involved in like Indian Patent Act 202 since 2006. She has been with Council of Scientific and Industrial Research, and she is presently principal scientist, and she has been associated with 3 journals. So इनके तहत 3 जर्नल हैं निस्पर के, जर्नल ऑफ इंटेलेक्चुअल प्रॉपर्टी राइट, Indian Journal of Engineering and Material Sciences, and Applied and Innovative Research Journal. She is a regular faculty for short-term courses on intellectual property right conducted at CSIR. So we all are fortunate. And apart from all these, her responsibility, she is even active in the social field also. She is also Secretary of Indian Women Scientist Association, that is IWSA, honorary member of Indian Institute of Management, Ahmedabad, Administrative Staff College of India, and Dr. Malik has been awarded with many awards like Distinguished Scientific Award, like Young Scientist Award, Science Communication Award, Young Scientific Fellow Award. She has also been a member of number of national and international scientific committees, delivered invited talks, presented papers. So list is so long. She has published many research journal in international repute, and she has even guided the PG and other students. And presently, I already said that she is heading the 3 journal. So most welcome, Dr. Kanika Malik. on our own platform. And then over to you, Dr. Kanika.
Thank you, Dr. Ruby. Very extensive biodata which was elaborated by you. And I would like to share one thing with these audience that because this program is being organized by Kalindi College. So I remember when I was looking for admission in Delhi University back in 1991, the first form which I filled was for Kalindi College only, and I visited the college for a BSc program. But thereafter, I shifted to Maitri College. I did my botany honors from Maitri, Delhi University, South Campus. So now I could see that हम कहते हैं ना धरती गोल है, गोल घूम के हम वहीं आ जाते हैं. So today I am with Kalindi College again. Thank you very much. Now it's my pleasure to be on this platform, and I will be sharing whatever I know regarding this intellectual property rights, my experiences, and I expect that you can interrupt me in the middle of the presentation. You can ask questions thereafter. I am always available. I am always available for this Yuva Shakti at any point of time. So thank you very much. Now I'll start my presentation.
Suman Suman ji has also joined. Suman ji, आपका स्वागत है. आप हमारे पास आए हैं. बहुत बहुत धन्यवाद. आज कनिका जी का उद्बोधन हमें सुनने को मिलेगा. आपका सानिध्य प्राप्त होगा. इंद्रप्रस्थ शक्ति से आपका बहुत बहुत स्वागत है कालिंदी कॉलेज के परिवार में. नमस्कार.
नमस्कार. Thank you.
Is it visible? आप सबको दिखाई दे रहा है प्रेजेंटेशन?
यस मैम. थोड़ा सा जूम कर लीजिए इसको, अगर आप प्रेजेंटेशन मोड में नहीं देना चाहते तो.
नहीं, मैं प्रेजेंटेशन मोड में I'm okay with it.
ओके मैम, देन डू इट इन प्रेजेंटेशन.
ओहो.
प्रेजेंटेशन मोड के लिए पूरा स्क्रीन को शेयर करना होगा. पूरा स्क्रीन शेयर है?
नहीं मैम, ऐसे भी हो जाएगा.
चल.
नीचे से जहाँ पर मैम, जहाँ पर 89% लिखा है.
हेलो डॉक्टर कनिका.
आई थिंक शी इज फ्रीज्ड आउट. आई थिंक
क्या एग्जिट हो गया?
नहीं, कैमरा तो
girls just have patience. You all know कि इसमें technical problems possible हैं. Yeah, she's back. डॉक्टर कनिका, उसको फुल स्क्रीन कर लीजिए या स्क्रीन शेयर मोड कर लीजिए. आपको पूरा स्क्रीन शेयर करना बेहतर रहेगा. हाँ, आप पूरा स्क्रीन शेयर कीजिए और अपनी पीपीटी खोलकर उसको फुल स्क्रीन मोड पे चला दीजिए.
अब ठीक है?
यस.
अभी तो छोटा दिख रहा है. अब आप उसको फुल स्क्रीन मोड में जाइए.
I think she's doing in presentation mode.
Is it all right?
आप देख पाएंगे अपने आप भी. आपका ये जो नीचे की तरफ एक नीचे एक आपका फुल स्क्रीन मोड का बटन होगा, उसको दबाइए. नहीं तो आपने क्या शेयर पूरा स्क्रीन किया है या आपने
प्रेजेंटेशन विंडो शेयर किया है?
नहीं, विंडो शेयर करेंगी तो जब आप फुल स्क्रीन जाएंगी तो फुल स्क्रीन नहीं नजर आएगा. आप विंडो पूरा स्क्रीन शेयर करिए.
स्टॉप शेयरिंग करती हूँ.
हाँ, स्टॉप शेयर करके आप पूरा स्क्रीन
100% भी जूम कर सकते थे. वो भी
चलिए आप कर लीजिए. आप पूरा स्क्रीन शेयर करिए.
कर देती हूँ. और प्रेजेंटेशन खोलना पड़ेगा ना पहले?
यस मैम.
आपको मगर नीचे का बटन दिखना चाहिए जहां से आप प्रेजेंट करती हैं. प्रेजेंट के 3 ऑप्शन आते हैं. स्क्रीन जरूर प्रेजेंट कीजिए. अब आप इसी को जूम कर लीजिए, बड़ा कर लीजिए देखने में थोड़ा सा. हाँ, ये ठीक है. हाँ, एकदम परफेक्ट. प्लीज गो अहेड.
So now to start with, we'll be talking about intellectual property rights, and then I'll be sharing my knowledge, like how you can enter into this field. Because when we talk about intellectual property rights, this field is not specifically for one subject, for students of only one subject. Anybody from any subject, even from the art field, even from the humanities or commerce or scientific field, they can enter into this intellectual property rights domain. So I'll be sharing this, how you can enter into it, and what you will get out of it, what are the career options, and what to start with, what is like intellectual property. If we understand what is the property and what are the rights attributed to these kind of properties, then we'll be able to like justify, and we'll be able to choose, like, is this the right path for all of us or not. So to start with, when we talk about intellectual property rights, so this term is formed by three words. So intellectual property and then rights. So when we talk about property, property means anything which we own. Like we have a house, we own that property. We have some money, that is our property. We own some jewelry, that is our property. So these type of properties are the properties in which we invest and we get high returns. So these properties are known as tangible properties. Tangible means those things which we can see, we can touch, or we can like put them somewhere else. We can use them, we can like load them, unload them. So all these type of properties, they are called as tangible properties. But there are other properties also, like intangible assets. Intangibles are those which they comes into the property. They have those properties of a property. They are defined as a property. They can be used as a property, but still they are intangible. We cannot see those properties. We can have the benefits out of these properties, intangible ones, but we cannot see them. But still they can be used as a property, and they are an important asset with all of us. Today, I'll tell you, if we don't have anything, right? I'm presenting before you. I'm not having any, you cannot see my property. I'm just sitting before you. But the intangible property which I'm having is this kind of knowledge which I'm sharing with you. This is the knowledge which I generated. And in this generation, I used my brain. I used my mental capacity to generate this type of experience, to get this knowledge, to grasp this knowledge, and how to interpret that knowledge which was available in the public domain. And now I am giving that knowledge to you through my intellect. So this intellectual intervention comes under my intangible asset. So this type of properties which are being possessed by a human being comes under intangible assets. So intellectual properties are intangible assets, and they are being associated with some human intellect. That intervention is required to define those kind of properties in this intellectual property criteria. So all those properties are called as intellectual properties. So, but the kind of benefits we generate out of the properties is same, whether it is a tangible property or it is an intellectual property. So if benefits are same, and I would rather say that benefits are more for an intellectual property. Why? Because there is higher scope of expansion. This is a limitless scope of expansion. With tangible properties, there are defined boundaries. But when we go into this intellectual property, the boundaries are limitless. So this type of intellectual properties, if we want to exploit for our own benefit, so that is the only, that is, I could say that that is the best option as of now in today's era. If we know what is intellectual property and how to harness benefits out of this intellectual property. So intellectual property are of two types: industrial property and then copyrights. Normally we say that intellectual property, one of the property is copyright, and then there are other trademarks is there, patents are there, but they have been defined separately because they have different type of rights for each type of intellectual property rights. Now industrial properties are all those intellectual properties which are which can be manufactured at industrial level, which have some industrial values associated with them. While if we talk of copyright, though it is a property and it is being generated by a human mind, but that type of property cannot be manufactured at the industrial scale, that cannot be harnessed. This property lies with the creator during his lifetime, and there is a certain period even after the lifetime. So this is the major difference between industrial property and the copyright. And with copyright, if we talk about, copyright comes with a bundle of rights, while other industrial property, whether it is a trademark, a trade secret, a patent, integrated circuit layout designs, or some confidential informations, know-hows, all this type of, and even geographical indications, these type of properties, they are industrial property and they have certain limited rights. But with copyrights, there it is a combination of bundle of rights. Many rights are there to only the creator of that type of intellectual property. And there is again a major difference is that when we talk about industrial property, the rights are once they are created, the rights are on the creation. But while in copyright, those ideas, different creations, forms of creations are being protected. Like if today you write a poem on a piece of paper, so you have a copyright on that piece of paper, on that kind of or that form of expression. But if that same poem you write on a digital mode, then you will have different copyright on a CD or any kind of software. So this is the difference between industrial property rights and the copyright related rights. And obviously, since these are all properties, whether they are tangible properties or intangible properties, our nature, if we have generated something, we wish to protect that creation of ours to most to the most of the period, and for the benefit of ourselves and for the benefit of our legal heirs. So this is the fundamental criteria behind providing protection for these kind of intellectual property. Now these type of protections are being given by whom? These rights are given by the government, the judiciary, the statutory bodies, who are involved in the governing process. So these are statutory rights. That means what? Once the government assigns certain rights, like we have our civil rights, we have our fundamental right from today onwards, and we can exercise but only after the grant. So this 8 years, this post facto right exercisation can only be performed after the grant of the patent. But while in copyright, copy, right to produce, right to perform, right to reproduce, right to assign. You can assign your rights. So all these are the bundle of rights. While in patents, you have only the right to sell, right to mortgage, right to like industrially manufacture that rights. While in copyrights, you have all those rights. You can in fact change the form. You can change your form. Today you are writing a book. Tomorrow you can perform a play on your book. Then day after tomorrow you can make a film on your book. So all these rights are only with the copyright holder. And these rights are in every field, whether it is a artistic field, it is a poet, or with the softwares. Even softwares are protected under copyright, they are not protected under patents. They come into patents, though they are technological interventions. But if they are a part of the integrated hardware, then only that hardware along with the software can be protected under patents. If it is simply a software or some kind of a flow diagram or some kind of a chart, then this can only be protected under the copyright. And if we write a book, all these authors, they are getting this protection as an author for that particular book. Like J.K. Rowling is the copyright holder for Harry Potter. So any Harry Potter, with the name of Harry Potter, the book can only come out of J.K. Rowling. No one other person on this earth can write Harry Potter. He can write similar fiction. He can take the idea from this book, but the expression has to be his own expression, and the title and whatever branding he wants to give to that author or to that creation or to that story, that has to be different. Then only he can enjoy the copyright. But if anyone writes that I'm writing Harry Potter, then he is eligible for the conviction. The court will convict him and he will be infringing the rights of J.K. Rowling. Rowling can sue this person and can get hefty amount of compensation or penalty out of that person. And in fact, I would like to share here that all these rights are cognizable offenses. That means the persons can be, if they are found that they have violated the rights, all these violators can be put behind the bars. In case of in the India, we have this Copyright Act of 1957, which is enacted, which is like prevalent today. It was enacted in 1957. So this act is still working for the copyright cases. And in the act has been amended many times, and recently it was added that the person who is of the cadre of the sub-inspector, he can directly seize the product, he can directly issue the warrant against the violator and put him behind the bars, and the time period is from 2 to 5 years. And even the monetary penalties are also there, depending upon the gravity of the crime he has committed in copyright related cases, and that is from 50,000 to 2 lakh rupees penalty he has to pay. So that is the amount and all. So even they can be protected under copyright, because the type of creature or the type of figurines which are being engraved on these totem poles, they came out of some kind of human intellect was involved. So all these things I have listed very few. Many things are there which comes under the this subject matter of copyright. They are protected under copyright. Now, when we talk about the industrial property, in industrial property, patents are there, designs, then trademarks, then geographical indications. For patents are given for the inventions, for the products and the processes of those inventions. So I have given one example, furniture caster. So why like these patents are being given some rights? Because all these type of industrial properties, somehow they are solving some kind of problem which was earlier there with the society, with the industry, and that problem solving component, requires some human intellect, and that is the only thing which is being protected, not the whole thing. So the problem with the furniture caster was that the furniture was very heavy in very like initial times when furniture was, like I can say, when furniture was invented. So it was invented without wheels, and wheels were invented separately. So someone thought of that if I want to shift this furniture from one place to another, I need some kind of support. So with this, wheels were available, furniture were available, but that human intellect was not available. It was thought of only by one person who thought of that if I put this type of wheel in the furniture, it is easy to shift. So that's why these furniture casters were protected under patents. They were given patents. 20 years protection was there. Then if we come out for designs, different designs. The same company, Coca-Cola company, have many. Why Coca-Cola company? The same drink is available in different design bottles, because each design has a value associated with it. They establish their brands with these designs. So they invest in the designs because they are earning out of these designs. That's why in this industrial property is so important. So designs are for the shapes, for the patterns, for the configurations. When we come for this trademarks are they give value to that company. Like I've shown Godrej written in some different manner. Earlier it was written in black and white. Now it has been changed, but the pattern remains same. Why? Because company has established this trademark since ages. Now anyone buying a Godrej product knows that if it is coming out of Godrej, it has certain types of qualities associated with it. So one can, even with the closed eyes, they can go to the market, and if it is a Godrej brand, they can buy it. So that is the value of a trademark associated with certain goods. Trademarks can be a word or a name or a logo, even a smell. Smell of a product is also a trademark. And even the jargons, the slogans, the poetries, like you must have listened to Everest का तीखा लाल, एक advertisement आता है ना, मिर्च का advertisement है, chili powder, Everest का तीखा लाल. So that means what? Everest का तीखा लाल means that mirchi powder has certain qualities associated with it, and that Everest ka tikha lal is associated only with Everest company. So that is the kind of trademarks or the brand value which are being associated with different companies. When we talk about geographical indications, they are for the place of origin and the appellation of origin. Darjeeling tea is being protected under geographical indications because that tea, that aroma can only come out of that due to the geographical conditions of that particular region. So this kind of logo is, this logo is available on certain product or any tea product, that means that is being protected under geographical indication, and those particular qualities of the tea leaves or the aroma is prevalent. And similarly, Swiss watches. Swiss watches are available because of the specific skill which is available in that region of Switzerland, and that craftsmanship, that skill is not available anywhere else of that caliber. So they have attained the value because of their geographical indication. They are given these type of tags that they have this type of qualities. Now for patents, what they do, what industrial like value do they have? They improve the quality of our life because of small technological advances which they do. Like I was giving the example of furniture caster. And even I will give a very small example. You must have seen U-clips. U-clip is very, like we can say, very small invention or very trivial invention, but this is being protected by patent. Because earlier we used to have, because it solved a major problem. These with problem was with the all pens. When we used to tag these papers, a bundle of papers, it was difficult to tag a thick bundle of paper. There was a problem with the all pen that it was very sharp and we used to hurt our fingers. But with the invention of someone thought of that why not I should fold this all pen in a certain manner so that it can hold a thick set of paper. So when he started folded in different design. Then one design he finalized. Okay, this is the good one. This is the best one. And then he went for a patent. So this was patented. U-clip is a patent. So these patents, what they do, they give different products. They produce new products, new processes, new manufacturing techniques in the market. So if these patents were not there, these type of products will never come to the market. We will never come to know what can be the solution to the problems which the society is facing these days. So patents are very important. When we talk about trademarks, for trademarks, they establish the brand loyalty. They establish the brand awareness in the masses. And they also establish the quality and the goodwill of that particular company. For designs, the different bottles of Coca-Cola, they establish new styles. If I am not liking this particular style of a Coca-Cola bottle, maybe this type of generation is like when these cans came, the cold drink was launched in the same cold drink was available in can. So these cans, they fascinate young generation. That's why they were launched. So with the launch of the cans, the Pepsi can, the Coca-Cola can, immediately the sales of this cold drink, they went very high. So that's why these industrial designs are important. And they also facilitate us in the selection of the product, off the shelf. We can say, if I want a product of this particular design, then I will straight away go to that shelf only. So different designs, they allow us, okay, then we have a variety of for these consumers, they can select out of those products. And GI, obviously, they give some kind of value to that commodity. For Swiss watches, the whole Switzerland now is known for watches. Swiss watches are very famous. Darjeeling tea is famous. Then we have our Indian products also. I'll be telling you many examples are there. And nowadays, I have come to know just few days back that we have applied for the GI of our Ganga Jal. So this is a matter of pride for all of us. Now our Ganga Jal will be protected by geographical indication. Now I was talking about the patents. The subject matter which is being protected under the patents is new and the useful machines, products or any articles or any process or method or manner of manufacture of that product. I have shown you the picture of a motorcycle. In this motorcycle, all technologies, whether it is a ignition technology, whether it is a wheel technology or alignment or whatever technology is there, or any products which are used, or a combination of these technological parts, or any part, even a small plug, ignition plug of this motorcycle can be patented if it fulfills the criteria of a patentable subject matter, if that is a novel plug, or the process is novel, or the product is novel, or it has some kind of inventive step. Obviously, industrial capability is there in that product, so it will be covered under that. But these three important features, if that technology fulfills, that can be protected under patents. For industrial designs, all industrial designs can be protected. We cannot say patented. Patent is only for S&T interventions. For outer dimensions, for 2 or 3 dimensions features, they have to be registered under industrial designs. And these designs, they have to be dictated essentially by technical or functional considerations. It is not like that. A chair has to look like, I have given you 3 pictures of a chair. So chair, the basic necessity for this kind of protection to apply for an industrial design is that it should have some basic features. Basic features means the functionality of chair is to rest the body. So some seat must be there, then some armrest. If armrest is there or not, it doesn't matter, but seat and some feature so that that chair can rest on ground. Any kind of feature. So these type of these are called as the essentially dictated technical features. Those have to be there. Otherwise, everything is possible under industrial design. This is the subject matter. Any visible design, symbol, words, or combinations. Even the combination of a sign, a symbol, or a word, or a slogan, or a smell. All these combinations can also be protected under trademarks. Like here, I have given you a whole bunch of this Unilever products. This Goodnight is also there, Stella. Then we have air purifiers are there. Then we have Easy, which is the liquid, we can say wash, detergent wash. And then we have Hit spray with the name of Hit. Now they have different brands, but they come out of single company. So they are the trademark of a single company. And similarly, these are trademarks of Godrej. Godrej आपको डिटर्जेंट भी दे रहा है, गोदरेज आपको एयर प्यूरिफायर भी दे रहा है, गुड नाइट भी दे रहा है, सब कुछ दे रहा है. सिमिलरली यूनिलीवर का एक अलग ही पूरा ब्रांड वैल्यू है, उसमें इतने सारे प्रोडक्ट्स हैं. And then you can have that, like if this product is coming off from Godrej, so this particular mosquito repellent will work. And if this product is coming from this some other company, it may not be of that efficiency. So that kind of brand value is being associated with this Godrej. Now Godrej also produces the dishwashers, the washing machines, the refrigerators, then TVs, then ACs, everything. So these are electronic items, and the upper figure is that are daily grocery items or detergents and utility products. So, but the quality which is being associated with Godrej is same for all of them. So this is the type of, like we can say, importance. So if we are working on in the field of intellectual property rights, we can assess, like, I am capable of what kind of job in intellectual property field. These are also the trademarks. I was talking about the Unilever one. There's Rin, Surf, Safe, Vaseline, Lifebuoy, Ponds, then Rexona. Then we have Kisan. Then we have Brook Bond, Medimix. Medimix soap we all know, but we don't know this Medimix brand is of which company. It's Cholayal Limited Company. So that Cholayal Limited Company nobody knows, but Medimix we know. So if we see anything, tomorrow maybe have some detergent, maybe have some kind of hand wash, maybe have some kind of lotion coming out of this brand name Medimix. So we know if it is Medimix, it has to be some kind of a herbal combination, because Medimix was established with herbal soap. So this type of like faith we can develop into the consumers. Now geographical indications, I told you that it is because of the particular good which is being originated in that territory or a region or locality where a given quality or reputation or any characteristic of that good is attributed because of its geographical location. Now these are few I have listed. There are many, more than 250 geographical indications which are being filed with the geographical indication registry offices. This Kolhapuri Chappal is GI of India because of the craftsmanship which is being associated in the Kolhapur region of Maharashtra. So this if someone else sells the chappal, similar looking chappal with the name of Kolhapuri chappal, that person can be sued. So this is the kind of value which is being associated with the craftsmanship of Kolhapur. Then we have filigree, silver filigree of India. Then we have Ikkat. Ikkat sari design is being registered as a GI for India. Then we have chicken curry craftsmanship of Lucknow. Then this is Chanderi saris. These all these Chanderi saris. Then we have this beetle pan leaves of Nagpur region. Then Rasabala bananas. Then we have Kondapalli toys. Then Nagpur oranges, Kanjivaram saris. Everything, all these things are being protected as a GI. In fact, in GI we have Tirupati Laddu, the prasadam which is being made in Tirupati for our Lord Vishnu. The kind of skill, the kind of what we say, the culinary expertise which is being required. In fact, it is not only the certain protocol or certain procedure which is followed in Tirupati Laddu. It is with a certain mind frame. You are at certain calmness level. You are in that boundary. You are in that region, and because of you being into that region, or the people working there making laddus for the Tirupati Balaji, so that type of, like I could say, the indication or it is only because of they are being prepared there. So if someone else prepares laddu at their home and then they say these are the Tirupati laddu and these are the prasada of Tirupati Balaji, those cannot be protected. Only those laddus which are prepared there, they have this kind of protection. Now, these are the various laws which are prevalent in India. We have Copyright Act 1957. It has been amended in 1999. Then Design Act 2000 is there. Then Trademarks Act 1999, Geographical Indications, Patent Amendment Act 2005. Then we have Plant Variety Farmers' Right Act 2001 and Semiconductor Integrated Circuits Layout Design Act 2000. So we can exercise our rights under these various laws. So now I have given you a brief introduction of value of intellectual property. How valuable is this field? If we want to have our career in intellectual property rights in India, what different type of careers are available? We can be the examiner of patents and designs. We can be the registrar of copyright, trademarks, or industrial designs, all these IP, intellectual property rights. We can become the registrar. We can become the IPR agents. We can work as IPR agents, as associates, as lawyers. We can work as IP managers, intellectual property managers of different firms. And then there is a possibility of working in this field as in the universities, as professors or researchers. We can do research in this field. So there various platforms are available. When we talk about the examiners, controllers, and registrars, what do they do? What is their role in this in these intellectual property is that the examiners, what they do, once these type of intellectual properties are filed with the patent with the offices, whether it is a registry office or a patent office or a trademark office, registry office, they examine the application as per the law. The law list I have given you, and according to their field of specialization. Like when I joined patent office, I joined as the examiner for the patent applications in the field of biotechnology. So I used to deal with biotechnology applications, microbiology or biochemistry applications. We have specialized examiners for specialized field. And when they examine the applications, they report to the controller with their decision that I agree to this application or to this filing, or I do not agree, with their observations under the law about their patentability or their registrability under copyright or their registrability under trademarks. Then they also do the search for anticipation, because all these intellectual properties, they are protected. They have the basic feature that they have to be novel. Novel means not the relative novelty, it has to be absolute novelty across the globe. So they search for their anticipation, then they classify in the international patent classification, like that particular file comes under which field. So it has to be classified. Only the laws are applicable as per the classification only. Then a detailed examination report is being prepared. That examination report is known as the first examination report, that is being shared with the applicant. And then the applicant and the intellectual property office has got a certain period, which law says that like for the patent, it is 12 months period. The file moves between the applicant and the examiner to put that application in order. Now, this is an obligation on both the applicant and the examiner, either reject the application or grant the patent. So, for that 12 months period is given to both of them. Then, these examiners and the controllers, they act as the chairman or the member of opposition board, and they also assist controllers in opposition matter. That means what? In the if there are some opposition cases, there is some kind of fight between the applicant and some opposition party, then there is a type of moot court which is being held with all the intellectual property offices, and there the examiner, the controller, they act as the judge. Whether they agree to the opposition party, to the arguments of the opposition party, or to the submissions of the applicant or the this patent holder or the patent holder, the copyright holder. Likewise, there are these matters are being solved. So they are very important matter, and the judgment lies in their hands. And they also act as, because India is signatory to most of the treaties at the World Intellectual Property Organization. So in India we have International Search Authority, then we have International Preliminary Examination Authorities, and all these authorities, all these offices, they work under World Intellectual Property Organization. So we have wide and very ample opportunity if we want to go into the government system in the intellectual property. These are the government systems. When we talk about the private sector, in private sector, the possibility you can manage all the intellectual property of the companies, of the traders or the businesses. So there, what is the role? The intellectual property experts, they prepare the patent landscape reports. Then they devise the product development strategy for that company, whether that product is, whether they should go into development of this product or they should drop the idea. So that kind of like what we can say analysis they do, then they suggest, they put their remarks, and they advise the manager or the management to ensure non-infringement of products or the patent filing, even the prosecution. And then they strategically they show the managers that what is beneficial for them, what is the asset they have, and how they can utilize their IP assets for the growth of the company. And they can only do if they are very familiar with the laws, they are very familiar with in that field. In fact, if they are IP manager of some pharma company, so they have to have that kind of techno-legal knowledge, technology knowledge of the pharmacy and the legal knowledge of all the acts. So that has to be there in place, then only they can work better in IP management of their company. Then they can become the IPR agents, associates or lawyers. What do? They draft the applications, file for Indian filing, for foreign applications. They handle the formality requirements. Formality requirements are the legal requirements with the Indian Patent Office or any Indian IP office, and they assist in coordinating with their foreign associates also. If there are any prosecution cases, so that language can be well understood only by a person who has this techno-legal language, who knows how to interpret the laws and how to put those laws for the benefit of the protection of the technology. Then they also prepare the response to all the actions of these government offices, like the first examination report, then the second examination report, they reply and then they re-reply again and again. I was telling you, for a period of, like, for the patents it is 12 months. So for the 12 months, they again some new affidavit is being prepared by these IPR agents. Then they communicate between the client and they report to the client, they report to the patent office. And they also conduct these searches for the criteria, for the patentability criteria, whether the client should go for a patent or he should drop the idea, because it does not fit into it is not suitable according to the law, or it is not suitable according to the criteria laid by the law. Then they also prepare the landscaping of those patents or the technologies, then invalidations, patent infringements, all these type of things, and they give opinions and they prepare assignments. Then IP monetization they do. They go for license even if they are not they do not have any technology to patent, they do not have anything to register or to protect. Then if they have this IP knowledge, so this IP knowledge would help them in going for licensing in companies, like how to sell their technology or the protected IP to different companies or to the markets or to different clients. So they can suggest in that also. And of course, if there are certain prosecutions, these are the persons, only agents can fight the case, not the applicant. It is as per law, because some legal degree has to be there. So only with this IP agents, you need not to have any LLB degree. If you are registered as an IP agent, you can directly prosecute in a court. But why we need this IPR as a career option? Why it is so important? In recent era, you must have seen that the number of patents, the copyrights, the trademark, it is a very burning field. It has grown over 15% in last 2 years. We were sitting at our home. There was COVID pandemic. In spite of that, the 15% growth is there in intellectual property filing with the patent offices or any IP office. So you can see the amount of growth available in this field. And why it is so? Because now with the awareness, the government of India has also launched this IP awareness mission. And it was launched last year under the Azadi Ka Amrit Mahotsav. Now till 15th of August this year, this mission will complete, and this IP offices are being engaged to create so much of awareness. And it is because of that awareness, even the local vendors, local businessmen, they are also going to file their intellectual property with the offices. And they are getting humongous amount of monetary benefit out of it. Now they have some kind of property which they can sell at their own interest. They can negotiate with the public. So that type of power is there if we have some kind of intellectual property. Then patent docketing, patent searching, paralegal jobs are there. These paralegal jobs are outsourced in India. Like the companies are foreign based. What they do, because they want to capture Indian market, all these industrial property are territorial properties, right? The rights are territorial. So if any company is working in US and they want the right in India, they have to file in India their product or process or whatever their invention is there. So if they have this manpower, IP literate manpower for their job in India, they outsource this job to the Indian experts. So this is the type of market which is available for our youngsters. For example, IBM is outsourcing work of patent analytics to Indian engineers in India. They are not hiring. They are not hiring these Indian engineers in US or in UK or any other company. They are giving this type of jobs here in India only, and they're paying handsome amount of salary to these are Indian engineers because they are getting their job done while in India. Then this GlaxoSmithKline is outsourcing work of prior art searching to Indian pharma graduates. Then legal services, why do they do? If these legal services are being availed still there, or I'm just going on?
Ma'am, we are here.
We are here, ma'am. We are here. We are listening.
Okay. So these legal services are too costly in US. So processes of patent docketing or communication or licensing with the patent office is being nowadays it is being done by Indian law firms. Why? Because we have this young generation who is working in this intellectual property field. And if we are working in a very international brand or in some MNCs, these companies have a very good research budget, and they mostly spend their research budget in patents because they are harnessing good amount of money. They just, what do? They develop a product, then a small kind of intervention they do. It is called, it is being debated many times, evergreening of patents. So what they do? They do one patent, then they file for some kind of intervention, small intervention, file another patent. So for 20 years for this main patent, some next patent on the same thing, 20 years again. So this is known as evergreening of the same patent. So they can play with single product for many years. So this is the amount of money which is there in this market. Then these IT industries like Google, Facebook, Samsung, IBM, they are doing this. Then healthcare industries, Renbexy, Dr. Reddy's, like options are available everywhere in this intellectual property field. And even now the UGC has also made it mandatory to have IPR cell in each of the universities. All the research organizations, DST has made it mandatory to have IPR cell in all R&D organizations or institutes. So one can apply anywhere for any, like if you want to apply for assistant professor or a lecturer, there is always a column, desirable qualification. So if you have a desirable qualification of intellectual property, some kind of course, some kind of degree, so you can be one of the person who can be deputed for these IPR cells because you have that kind of expertise, you have that knowledge. So you can go into this field. And these companies, they create and market their products at a very global level. So it is not limited to just one country. I was telling you, they like patent in one country, then they want to capture another country. They go for the patent for the same product in that country. But of course, within the ambit of law, because there is a provision of PCT filing that is called Patent Cooperation Treaty. Under Patent Cooperation Treaty, one can file in one country, and then as Indian Patent Act says that within the framework of 12 months, they have to go for Indian filing. So likewise, different countries have their different patent acts, so they have to work into the area of that act or those sections or those rules. They have to obey those rules, and within that they play and they capture market of all the countries at the similar level. Then when these products are launched in multiple countries, so IP department, in the department which I am telling you that you will be working in this intellectual property department, they will give you an extra edge to other employees, because other employees, what they are doing, they are working in a particular domain. Like they are developing a single product, so they have expertise of that. Like he's an engineer, so he will develop a software. But since you have that knowledge, you know software also, you have that legal knowledge also, you have intellectual property knowledge also. So your area, your growth will be much faster than the subject area expert of that particular field. So this is all I wanted to share with you, that it is a very good opportunity for all of us to work in this field. If there are any questions. So
yes, thank you so much, Dr. Kanika. So I take now questions which are there on chat box. So one of the question is that how much time on an average patent takes to confirm or publish? And after filling, how to follow up for study work, speedy work? I think this question is from Dr. Savita Sharma.
Average time of filing, right?
Yes, average time a patent takes to confirm or publish.
Confirm or publish. That means to grant.
Yes, ma'am. Yes, ma'am, to grant.
Yes, ma'am.
Yes.
Yes.
Because patents are filed and either they are rejected or they are granted. This is the only, they work only in this manner. So, when we, first I'll tell you how to file. There are two types of filing for a patent. If our technology is ready today, we can directly go, and we are very sure that this is the only technology we have and we don't want any kind of improvisation in that technology, and there is no possibility, and we have tried each and every procedure or a protocol has been followed, and these are various 10 methods in through which my technology can work, and this is the best method. So if this whole information we have, we can directly file as a complete specification with the patent office. That is called patent filing. There is another provision also which is called provisional filing. In provisional filing, the Act gives us 12 months time to file for a complete specification. Why complete specification? Because patents are granted only on the matter which we write in complete specification, not in provisional specification. So patents are written or drafted in a manner that we define the boundary. This is my boundary. In provisional specification, we can define the boundary. Then complete specification has to be within the boundary of the provisional specification. And then patent can be examined on complete specification only. So this is the filing procedure.
So she wants to know, I think, how much time it takes.
Time for filing is as
No, ma'am, after filing. Suppose it's been 3 years that I have filed a patent, but it still shows under review.
Actually, if you know how to draft your complete specification, it can be granted. If it is it fulfills all the criteria, it can be granted within a period of 9 months. Act gives the time period of 4 years for examination. I'll give you the timeline. Once you file the complete specification, 12 months are given to the applicant and to the examiner to put the application in order. 18 months period is given to the patent office to publish that application in the public domain to invite for any kind of opposition. Then 4 years period is given to the examiner to the applicant to apply for examination, because if the applicant does not apply for examination of patent, then that application, in spite of filing with the patent office, will not be examined by the examiner. It will not come to the table of the examiner. So this is the timeline which is being given by the law. But if your application is drafted so well, you can go for early publication. You file immediately with the form 2. We file the complete specification, right? There is form 2. Some fees is there with the form 2. Then you file immediately with the form 2, form 9. That is for early publication. You request patent office that my application should go for early publication. So in spite of waiting for 18 months period publication, next month your application will be published in the official journal of patent office. So once it is for publication in the open domain, if there are no objections, you are so novel, you have some inventive concept, everything is fine, then no objections are there, directly you file for examination of patents. Third month you go for examination of patents, then it will go to the examiner is being given 1 month period time. So by 5th month you will get the first examination report. And if that first examination report is all clear, no formal objection, no technical objections, then that report will be shared with you, and there is no objection, then examiner will directly grant the patent to you. So 9 months, within the period of 9 months, but it all depends how you write, what you write, if there are any objections to it or there are no objections to it, and how much time your lawyer takes or you take to put your application in order.
Okay, ma'am, thanks. There is one more question from Shweta. I think, Savita, your query is now...
Yes, ma'am. Yes, ma'am.
Okay. So now one more question is from Shweta Dubey. If a person gets an international patent will it be considered as Indian patent under the country or that person's specifically?
There is no international patent. Only the filing procedure is international. Patents are the territorial rights. They are always national rights. So there is a provision is given for international filing. Like if you go for a PCT application, all these international applications are called PCT applications because they are filed under the Patent Cooperation Treaty. And many countries are they are members to this Patent Cooperation Treaty. For those countries, if they want patent, they can go for a single application as PCT application. That PCT application can be filed with Indian Patent Office. They can be this application will be examined as a PCT application, but along with a national filing application. There is no international patent kind of a thing. Patents are always national and territorial.
Okay, ma'am. Amrita Tiwari wants to ask something. She has raised her hand.
Yeah.
You unmute yourself, Amrita, and say what you want to say. Want to ask?
Yes, ma'am.
Yeah.
Yes, ma'am. Thank you, ma'am, and good evening, ma'am. Ma'am, I have a question. As you told, we can opt this IPR as a career option. But, ma'am, actually, I am a life science student, and we have studied this IPR in semester 6. So, I have a very keen interest in IPR. But the problem is, I always have a query that we need to follow a step of law, or we need to do LLB. Like there is a course in IGNOU diploma course, but I don't think diploma courses have much value. So what should I do if I want to pursue IPR as a career? I should do law, or there's something else option as well?
Yes, if you are very sure that you want to have only this career, so you have to go for a law degree, or because it will give you edge over others. But it is not mandatory if you want to practice into intellectual property rights field. It is not mandatory for you to always to have a degree. If you are a registered patent agent with some kind of diploma or some kind of knowledge which you have, there is a test which is being conducted by intellectual property offices, Vadik Sampada Bhavan. They conduct this test, and those who clear, they are registered in the intellectual property office register as a registered patent agents. So if you are registered, thereafter after registration also you can go for some kind of course, but otherwise it is not mandatory. But I would say, if you are very sure that you will work only in this field, then obviously if you have a legal degree, LLB, LLM, you will have more clarity of the law, right? So then, in that case, you should go for a law degree.
I also want to ask, what is the minimum desirable qualification to pursue in this career?
For which kind of position?
It's like you were saying that to be an agent or something. So it is only graduation is required?
Yeah, undergraduation.
And to be an examiner?
For an examiner or post-graduation is required.
Post-graduation is the minimum qualification.
Yeah.
Not a PhD degree?
No, not PhD degree, post-graduation.
Okay, only a post-graduation is required.
Yeah. But you check with the new rules and regulations. When I joined in 2003. It was long back. And this is a UPSC position. So these interviews are being conducted by UPSC.
Okay.
You go through that.
Dr. Kanika, can I ask you something? Suppose something is designed in India, right? And then somebody just gives you a credit and uses the concept and the idea and takes a patent in USA.
No.
Takes a patent in USA. Okay. Now they give you a small credit on internet only, and then they take away that news item also, where they give the credit to University of Delhi, and they take a patent in USA. Now, can the initial party who actually gave that idea, can they file for a patent in India?
Yes. No, they cannot file a patent. Now the patent is in public domain. Once the patent is granted, it is supposed to be in public domain. It is now not your patent. But you can always sue that person. You can always get that patent revoked. Now he will not, you can always fight with that person and that patent can be revoked.
But if that patent has been taken in USA, how does the Indian government help us to fight with that person?
You remember the case of Haldi? That was filed in USA only, and we fought case over there only, and we won the case. Yeah, if we have proper documentation of our submission, that it is our property, we can fight anywhere, because India is also party to World Intellectual Property Organization. USA is also party member country. We both have signed the treaty that we will not violate the rights of our citizens, each other's citizens. That is our obligation at World Intellectual Property Organization. So one cannot just steal our property and execute his rights in US.
Thank you so much. Thank you so much.
One more question.
Dr. Kanika, yeah.
One more question. Ma'am, I want to ask, can we publish a paper on the work that we have filed it for a patent?
Yes, after filing, you go for publication.
Publication also.
Yeah, you can do whatever after filing, because your right starts from the date of filing.
Okay.
You can
So can we claim the points just by mentioning the application number? Because application number has been awarded, everything is awarded, it is under review.
Yes. Some number and then oblique del oblique something.
Yes. It's a long number. Yes.
Yes. You can always. Yeah. But only you try to publish only after filing.
Okay.
If we first publish and then we go for filing, sometimes we
it becomes difficult. Yeah. Then getting patent becomes difficult.
Yeah, it's difficult. वो वहाँ से objection for examination report में सबसे पहले आप ही अपनी खुद ही novelty clear
Yes. Okay.
So, Dr. Kanika, thank you so much. Maybe the young girls are thinking that this is all about big things or big companies or big inventions and big ideas. But I must tell the girls who are still here that you also have patents for small children. If a small child makes a new design of a cartoon, of an animation, or creates something, there are intellectual property rights even for kids as young as 8-year-old, 5-year-old, 10-year-old, if they create really something extraordinary. So don't think कि IPR और पेटेंट राइट सिर्फ बड़े लोगों के लिए और बड़े चीजों के लिए और बहुत बड़े साइंस के लिए होता है. जैसे कि मैम ने बताया, डॉक्टर कनिका ने बताया कि कलमकारी, आपकी कला, आपका क्रिएटिव आइडिया, हर चीज पेटेंट होती है. तो अगर आप रियली क्रिएटिव हैं, आई एक्चुअली नो अ गर्ल who patented her creative designs, and so it was really amazing that she was aware of all this. And we have today made an effort that our girls should be aware that if they are really creative about something, they can go for a patent. So Dr. Kanika, I thank you from the depth of my heart for taking out your time and spending so much of energy and efforts to give this knowledge to ourselves. So that means the colleagues that have joined with me and also the young girls. Thank you so much, ma'am. Thank you so much.
Thank you for inviting me to be here present. Thank you.
Thank you so much, Dr. Kanika. Thank you so much. Thank you.
Okay, so I can close the session formally today.
Yes, Dr.
Good evening,
Sarita,
everyone. See you all tomorrow again. Goodbye.